my eyes dare to see all the greatness I possess, endless possibility. Look in the mirror, what do I see?
Welcome to another segment of the Seek ELLAvation experience. Today I want to talk about the Major League Baseball Player Association and Aaron Judge, the baseball player Aaron Judge. I don't want to talk about it because of sports. I want to talk about it because of a very, very, very important message. Common law rights versus federal registration or federal protection when it comes to trademarks. The brand that identifies the source in which your products or services are provided. That is your trademark. It is a stamp. It is the brand, the branding on your brand. It identifies the source for the community, the consumers, to identify this particular thing is what I'm in love with because it comes from who I identify it to come from. So let us talk about the Major League Baseball Players Association, who joined Aaron Judge, and they opposed a federal trademark application that was submitted for trademarks that are identical to what Aaron Judge was using. Aaron Judge, who is he? He's a baseball player here. So we're not talking about sports. We're not talking about baseball. We are talking about the sport of life. We're talking about the sport of business is what we are talking about, because this case clears up one of the most misunderstood ideals in trademarks, in trademark law, what people have heard about trademarks. So this is not going to be about the celebrity status. None of that. And what it's going to clear up, what is misunderstood about trademarks is not just misunderstood because it's misunderstood. I will honestly say a lot of this misunderstanding do come from my colleagues in the legal profession that make certain statements that are not quite accurate. And I get why those statements may be made, right? Because a lot of times people do want to sell whatever they're doing. That's the purpose of you having a product or service. You got to find a way to sell it, find a way to market it, find a way to get people to buy it. Sometimes the way you get people to do that is by sharing a certain narrative that hopefully gets people to move in one direction, to hopefully mobilize people to move in one direction. But I feel it's best to be fully educated, because when you understand one side of information, it can still hurt you. It may encourage you to move in one direction, but it can also cause you to lose out on the other side of that misdirection. So I want to talk about the Major League Baseball, the MLBPA, that joined Aaron Judge in opposing a trademark application. And the 3 points I want to bring up using this case, using this scenario, are 3 trademark fundamentals I want you to walk away with. With the owner mindset, right? Being owners, being individuals who are leveling up in sports, as a creative, as a sports professional in general, as a founder, we must level up. So, a lot of people believe that if your trademark, remember that source identifier that tells the consumers where these products or services are coming from, if that is not federally registered, it doesn't really exist. Is that true? Let me ask you. If you have a trademark and you do not federally register it, basically you own absolutely nothing. You own no rights. It doesn't exist. It may be seen in the public, but you own absolutely nothing, no rights. You don't own it. Is that true? Well, let's find out. Let's find out if you do not federally register your trademark, if you own it or don't own it at all. Welcome again to another segment of the Seek ELLAvation experience. If you are new here, I am attorney Ella Keisha. I'm known as the empowerment influencer and also as the ownership attorney who advocate for creatives, sports professionals, founders, and I especially have a place in my heart for first-gen achievers, being one myself. Trailblazers who are the blueprint, who don't necessarily have one, but who are one. And that's the reason why I love to empower, because there's so many people out there who, like myself, had to figure a lot of things out, surround myself around a lot of people that can help me figure it out. And so that's what I do here. Seek ELLAvation is a space for elevation, transformation, and clarity. Right here is where I empower individuals who are rising and redefining themselves and daring to step into their highest potential. You know, the people who want to become the best versions of themselves. Yes, those people, and own every step of their journey. So if you are building, if you are creating, if you are leading, if you are evolving, this is the platform for you. So let's go ahead and get into it. So to save you the heartache, right? This is the case here. This is the case. I read the case, and we don't have to go through this case here. I read it for you. But you have Michael Chisena or Chisena versus the Major League Baseball Players Association. And this is because Michael decided, I'm going after these trademarks. I'm going all in. This is something that I want as a source identifier for the products that I'm going to serve. So I'm going to file a federal application, which we're all told to do. You have to file that federal application if you want federal protection. If you're out here moving like you are owner, it's best to file a federal application so that way you can own your brand. So he said, I'm doing that. What Michael did, he went on the USPTO website, which is uspto.gov, and said, I'm going to file an application for the trademarks All Rise, and I'm going to file an application for the trademark Here Comes the Judge, JUDG, and a related judicial type theme logo or design mark. Actually, it was right there when I showed you in the case. I was on the second page. So there's this right here, this image of this judicial type theme logo. And he filed the application for these trademarks, All Rise, Here Come the Judge, and the design mark for apparel, for clothing. Here are some key facts I want you to hold on to as I go through the 3 fundamental points that I want you to walk away with. Michael filed this application as an intent to use application. When you file an application with the USPTO, you have a choice. You can file an application that is for end use. Your application says, I am currently using this trademark. In commerce, meaning I'm currently using this trademark, selling products or services in more than one state. I'm not isolated geographically to one state. I have consumers who can purchase my product or service from multiple states. Whether that means I am placed, physically placed in different states, my products are, or my service are provided there, or I may be physically in one state, but my products and or services are accessible to people in other states. Hence, they can order on a website from different states and have it shipped to them. That's in use. Intent to use mean I have this trademark and I want to file this application stating I haven't used it yet. I am not in commerce. I am not selling products or services yet. They're not available for consumers in more than 2 states or more, but I intend for it to be, and I prefer and feel more comfortable if I go ahead and just submit my application to solidify this date before I even introduce it to the world. I want this application to be constructive notice that I intend to use this. So we can retroactively go back to this date when I'm ready. And when you file an intent to use, they give you a certain amount of time that you can then transfer it from intent to use to use. You can also file extensions if you're not ready by that certain amount of time or what have you. So Michael, he went ahead and filed an intent to use. I'm not using it yet, but I intend to use it. And he filed this application as far as 2017, I believe. It was 2017. So that put on notice constructive use. His constructive use filing date was 2017. Major League Baseball, in collaboration with Aaron Judge, came in. First of all, that means Aaron Judge had a huge backing. They had the MLBPA behind you as a named opposing party. Came in and said, no, I'm going to file an opposition to this application. So When you file an application on the USPTO, when it gets to a certain stage, the application will be published for notice to the public. A lot of people don't even know to go on or how to even find the Trademark Gazette and see what's out there or what have you, unless you have an attorney on a retainer who checks for these things, who checks to make sure that your trademark is not being infringed upon by people trying to file. Usually people don't even know about it. Well, they knew. They got wind of this, and during the opposition period, which the public gets a chance, a certain amount of time to oppose applications during the opposition period, MLBPA came in and opposed this application and say, no, we feel that this application should be stopped. It is infringing upon Aaron Judge trademarks. And the argument that the MLBPA and Judge had was that Aaron Judge has been using these trademarks in commerce already. He has been using these trademarks, selling apparel and merchandise, and using exactly the same phrases and the judicial imagery. So using phrases, because a trademark can be a phrase, a slogan, it can be an image, a logo. This case involved the two different types of trademarks, phrases and imagery. And they argued that Judge has been using this before Michael's filing date. So here's what we're looking at when we look at those two key facts. You have one who filed an application and say, I intend to use it. So it put the world on notice constructively, meaning because it's not, you either have constructive notice or actual. Actual means I'm using it. I put it on notice that I'm actually, constructive means it's because there's a documentation there. Constructively, there is a record showing that I'm claiming whatever it is that I'm claiming. So there's constructive notice. There's a record. The MLBPA, Aaron Judge, never filed a federal application, never filed one, but have been on watch just in case somebody else does file, obviously, because they got wind of it. Never filed one, but came and opposed the application and said, but this is still my trademark. Even though I didn't file an application, this is still my trademark. I've been using it way before this application. And I've been using it in the same manner for apparel and merchandise. Well, when someone opposes an application, it goes to the Trademark Trial and Appeal Board, which is the TTAB. That's what that stands for. The TTAB reviewed all of the facts and evidence and came back and refused Michael's application, refused to allow it to go forward. They sided with Aaron Judge and the MLBPA and said, you have senior rights in priority use. You have been using it prior, so your rights are senior. You have not filed for federal protection, but you have rights through what's called common law trademark rights. So now let's pause there. There are two types of rights that you can have in your trademark. You can have rights where you start using your trademark, you're past the intent to use, you're out there, you're using it, you're selling your products and services, and you're selling in more than one state. It's a nationally available product or service. You have now established common law rights just by use. Just by use alone, you have common law rights. If you decide, okay, I want to go a step up from common law rights and expand my rights, which I'll get more into in a second, I want to now file an application to expand my rights, tighten them up, and also put individuals not just on actual notice because I'm using my trademark and I have common law rights, but constructive notice. I'm putting it out there that if you never even bought my product or service, never even heard of me, there's still a record that I do exist, a record in which you should be checking. So I have actual notice because I'm using it, but I want to expand my rights, my protection, my notice. I now have constructive rights. I'm using it. You can file an application. Well, the TTAB said, okay, you have rights through common law. You've been actually using it. How long you have been using it predates the date in which the application that Mr. Michael entered in 2017. And those rights and how you've been using them, how long you've been using them, the type of consumers that have become familiar with your brand, all of that evidence says that those rights were sufficient under trademark law, common law rights, and we're going to block the application to move forward for registration. So, what actually won this case? Those are the three fundamentals I want to get into. And the question I asked you earlier, can you answer that now? Can you already, before we even get through the three fundamentals, if you have a trademark and you do not file a federal application, do you not own it at all? Do you not own it? Can you still answer that? If not, let's keep going. And if you can, let us keep going. So what are the three trademark fundamentals that I want to cover? For you, you got your notebook? You got your pen? If not, you're going to put this on replay. And when you get a chance to sit down, you're going to write it down. This is going to become a part of your notes for your business as an owner. This is something that you're writing down to level up. So let's get into the first thing that I just mentioned. Common law rights. Common law rights are real. The reason why the court reaffirmed this core principle is because it is real and it is still considered. Trademark, your rights in a trademark arises from use, not registration. Registering for trademark, federal trademark protection is exactly that. It means I have a trademark already. I already have a trademark. I'm not coming to the USPTO asking them to give me a trademark. I already have a trademark. What I'm doing is coming to the USPTO and saying, I want to elevate my protection. I want to expand my notice. So now I am operating truly as someone who owns something, because if you own something, you're going to try to protect it to the best of your ability. But it does not mean you don't own it. That's why when I share information about trademark protection, I always tell individuals, if you are able to federally protect your trademark, do so. Because without doing so, you don't outright own your trademark. There's a difference between telling individuals you don't own it to you don't outright own it. Because the difference between that is when you don't own it outright, there are several things that can happen. If you don't own your trademark outright, there is a possibility that you may have to co-own your trademark with someone else. Because with common law rights, there is protection geographically. It also may mean that you may have to start over. You may not own it at all. Because like in this case, you may not even know someone else exists. We're going to get more into that later. So it's best for you to understand that if you can federally protect your trademark, do so, because without doing so, you may not own your trademark outright. So that's why in this case, Judge didn't need Aaron, I'm gonna say Judge because I don't want to confuse you between whoever is assessing this case legally versus who's bringing the case. So I'm going to call Aaron Judge Aaron. So Aaron did not have a federal registration and he didn't need one to win this case. What he needed, because he had common law rights, what he needed to do was to establish actual use. That's one. In commerce, that I'm actually using it. I'm not intending to use it, because that's a major difference. If you do not file a federal application and you're not using it yet, you don't have common law rights. You don't have common law rights for an idea that's in your head that you're not using yet. You don't have it. So if you have created something and it's great and you decided I'm not sharing it with the world yet, and someone gets out there before you and shares it with the world, it's theirs. Because you have nothing, no evidence to show that that was yours out there for consumers to understand that is yours, actually or constructively. So the person who goes and file an application who's not using it yet, like Michael did, I intend to use it, but I'm gonna file an application, I now have a right before I even use it, because I now put the world on constructive notice. Picking up what I'm putting down? So that's why that's important. That's where the difference between owning and outright owning. You don't own it outright if you're not using it yet and it's just in your mind quietly on your computer or whatever, then someone can come in and use it. But in this case, Aaron actually was using it. So he had to establish, I have actual use under this common law argument. I have actually used it in commerce, meaning, again, I use it outside of one state. I used it in 2 states or more, because you cannot federally protect your trademark if you're only using it geographically in one state. You can get state protection. Individuals can file for federal trademark notice within each individual state, not just, let me back up. Individuals can file for state trademark protection. If I didn't say that, I don't know if I said federal or state. I had to go back. State trademark protection in each state, so individuals can understand and know and put people on notice in the state. But once you cross over to more than one state, now you can elevate and file for federal protection, meaning national protection outside of the state. So he had to prove actual use in commerce. He had to prove that what he's using is literally a source identifier. People say, oh, I should have trademarked this, I should have trademarked that, thinking everything can be trademarked. Everything can't be trademarked just because you said something that you think is popular, or whatever it is. You design something that you think is popular, some type of nice artwork, which you probably can copyright. If what you are trying to federally protect is not a source identifier, it doesn't identify the source in which a product is sold from, a service is provided from, it's not a trademark. So he proved actual use. He proved this is a source identifier. These trademarks I have, the consumers know when they buy this apparel or merchandise is coming from this particular source. And which brings to the third thing he proved is that consumers associate these trademarks with me. When they hear All Rise, when they hear Here Comes the Judge, or whatever the other mark was, what is it? All Rise and Here Comes the Judge. When they hear these slogans, these phrases, when they see this imagery, they associate it with me. So now I proved actual use. I proved that actual use in commerce. I proved that there's a source identifier. It's not just something that's ornamental. It's literally a source that identifies where something comes from. And I proved that consumers associate these things, these trademarks, with me. And then lastly, he had to prove that I was using this before Michael priority date. Because the only date that Michael had, the only date that he can use was application date. That was his date because he already said, right? The application was intent to use. I'm not using it. So you can't go before the application. I only can use the rights that is afforded to me through the USPTO, which is if you file this application, this will serve as your date. Even if you decide to use it later, even if you decide to use your trademark later, you're still not using it. The actual date of protection will be created from this application date. So Michael's date of use was the application. So because Aaron was able to prove all of those things under common law, he established senior rights that invalidated, that canceled out the application. That was enough. So yes, common law rights can defeat later applications. You may hear people tell you the first to file wins. Hurry up and file. The first to file wins. That is not true. The ownership attorney, the empowerment influencer is here to tell you that's not true. See, I don't want to trick people. I don't want to do fear mongering to get people to do something that they should be doing. I'm going to give you all the facts, all the evidence, all the truths for you to make an informed decision. If people's mindset is not at the level of operating at their highest possibility, that has nothing to do with me. Nothing to do with me. I don't need to put fear in people's heart to put money in my pocket. My vision and focus is to help individuals be their best selves. So the truth is what will set people free. Because even if people use fear tactics to get someone to move outwardly, they have not moved inwardly. So the results still won't manifest themselves. So yes, that is not true. If you ever hear someone tell you the first to file has the rights, that's not true. There may be some things that go on with that in real estate or whatever. When it comes to trademarks, the first to file does not mean you own the mark. There are common law rights that will defeat federal applications. Secondly, what common law rights can do is help you establish priority. You've been using it and using it and using it for years, and you have to show evidence of the date that you're going to claim that you've been using it and how long you use it. You're going to have to show evidence on that. But you establish senior rights, priority use rights by use, not in your mind, not on your computer, by use. And common law rights can block registrations entirely. So that's point one. Common law trademarks are real. They do give you the rights that you need. Point two, fundamental lesson number 2. And I want to expand a little bit more on a point I brought up in fundamental 1. Filing first means the same thing that you own it first. Now I want it to be its own standalone. It's important. Because you're going to hear this and you're going to say, I listened to Seek ELLAvation podcast and I learned something that is not necessarily true. Yes, it's best for me to go ahead and file and put that date on the application. It's best for me, but all is not lost because of it. And let me tell you why it's important for you to know that, because you may be on either end of that, just like Michael was. He thought the first to file, I have rights, but he didn't. You may be on that end versus just being on the other end of the one who has the rights in the first place. So you need to understand that first filing doesn't offer full protection either way. So Michael relied on this intent to use application to say, I'm first, I got it here. I'm the owner. I can stop everybody when I decide to actually use it. It's good. Well, the problem, the TTAB saw the problem. Constructive use, which is like I just told you, what do we say constructive use is? Constructive use is not actual use, it's the use that puts everyone on notice constructively, meaning a record, but not actual, a record. The TTAB said constructive use only matters if no one else, no other person is actually using the mark. That's when constructive use matter. So that goes back to the point I made earlier. I have a trademark that I invented and I intend to use. I'm not going to put it out there in the world. I don't want to tell anybody about it yet because I'm not ready to offer products or services. So I'm not going to tell anyone. Then you got somebody else who goes out there and does the application. They're also not ready to put out products or services. But they go out there and file an application to say, I intend to use this, but I'm not using it yet. They have constructive notice. You don't. So constructive use for Michael would have prevailed and would have been great if Aaron Judge never used it. But it did not. It failed. It didn't hit the mark because Judge used his mark earlier. So once Judge showed, as the opposer, showed real world use, actual use before 2017, and I believe it was July 2017, he showed actual use before July 2017 when the filing date of Michael, those dates became irrelevant. Constructive use became irrelevant. So the application first to file can become absolutely irrelevant. Just because you file first does not mean you own it if someone else can dismantle that whole thing, can invalidate that whole thing through common law rights. So walk away understanding that federal application for registration does not erase early common law use. That brings me to fundamental 3. Now I want to take that point and make it a full standalone because this is a point that is so important that could have saved Michael heartache and headache, possibly, because maybe, he said in the case that I don't even know. I don't watch sports. Michael said, I don't even watch sports. I don't know who Aaron Judge is. I did not know he was using all of these marks. We just so happen to have the same mind. I just so happen to pick these trademarks that are the same ones he's using for apparel. I just so happen, I don't know him. I didn't know anything about this. That argument didn't stand because fundamental point number 3. Why a clearance search matters. If you don't remember all three of these points. First of all, you should. You need to be writing your notes, and then you need to be listening to this over and over again. This segment right here need to be saved and shared. If you are a founder, a creative, or a sports professional, this segment right here need to be saved. But if for some reason you're walking around and you don't have access to your notes, or you can't push play on this video, if you walk away with one thing, understand that clearance search matter. What is a clearance search, Ella-Keisha? What do you mean clearance search matters? A clearance search is doing a search to make sure the trademark that you are using is cleared to be used. So when Michael made the argument, I have no idea who Aaron Judge is. I don't watch sports. I never brought his products. I'm not copying, ripping him off, infringing. The reason why that did not stand with the TTAB, the Trademark Trial and Appeal Board, is because they said, that's your problem. Because there's a thing that you need to do that's called a clearance search. You needed to make sure it was okay that you can use this trademark. You needed to make sure that these trademarks were cleared for you to use. And to do that, you must do a thing called a trademark clearance search. That's why it's important. There's so many people that say, okay, I'm going to file my own trademark. Rolling the dice with it. Some have rolled the dice and got very lucky, and a lot have rolled the dice and have not. You don't get your money back. None of that happens. You got to start all over again. There's a lot of individuals who have used trademarks for years without doing a clearance search and had to rebrand all over again. I have a reel that is on my IG that I shared a story about this. A woman was using her brand for over 5 years, built a multiple six-figure business, was doing great. Decided I'm going to take the next level up. I'm a level up, and I'm going to federally register this trademark I've been using because there's some more things I'm thinking about and how I want to expand. When she filed the federal trademark, then her application was was not approved. The opposer didn't even have to come in to push. The trademark, the examining trademark attorney, because when you file a application, when you submit an application through the USPTO, the person on the other side waiting to receive that application and start the process is an attorney. It's the USPTO attorney. So if you are filing your application, it's you as a layperson dealing with an attorney. And attorneys, a lot of us only know how to speak legalese. And we tell you, if you don't understand this, we advise you to get an attorney to help you understand this, but I don't have to help you understand at a basic level, because now I can't put myself in a position. This is the U.S. examining attorney. I can't put myself in a position as if I'm giving you legal advice. I can't do that because I'm not representing you. I am representing the USPTO. I can give you and explain to the best of my ability the information to help you make a decision, but I advise you to get an attorney. So, yeah, they'll go in and say, I can do my own application. They don't understand clearance search. They don't understand they're going to deal with an examining attorney on the other end. You don't do a clearance search like she did. You get an examining attorney that says, nope, application denied. Then she went and hired an attorney. Attorney assessed her situation, because a lot of times when you get an office action that denies your application, we can come in as attorneys and we will submit a response, a legal response to rebut the examining attorney's office action. And if we prevail, it continues to move forward. Well, this attorney that she hired, post submitting everything, came in, assessed everything, and said, you're SOL. There's nothing that can be done here. Nothing. You will be infringing upon. And there's no argument that I have for you. So she had to start all over. Not just with her federal application. She started all over with her business name. All over. Anyways, I covered that reel on my Instagram page, The Ownership Attorney. But clearance search would have helped her and would have helped Michael if they did a clearance search. So you have to go to the USPTO and you have to search their database. to see what's already federally protected. That's what the examining attorney is going to check. The examining attorney is going to check their database to see if there's a pre-existing registration that is exactly the same as the one you're trying to submit or similar. And similar enough that it will cause confusion to the consumer if they go ahead and approve your application. So if Michael would have searched the USPTO, he wouldn't have found it. Why? Because Judge did not submit a federal application for all of these marks. He wouldn't have found it. So a clearance search also includes searching outside of the USPTO database. It includes searching the World Wide Web, URLs, social media pages, state registrations. Because remember, I told you you can file for trademark constructive notice state by state for those who are not offering their trademarks outside of one state. You can file there. And so if there's someone who owns it in one state, then there's an issue. They can still oppose you to at least limit you from marketing your trademark in their state. So a clearance search is searching the USPTO database to see what applications already exist. A clearance search means searching outside of the USPTO database all over to see what exists, business registrations, names, and things that's already out there. Those things will put you on notice that even though they're not federally protected, they still exist. And if they still exist, then there may be senior rights, priority use rights that are protected under common law that can stop me from federally protecting this. So a clearance search matters. Michael lost because he filed, obviously, without clearing the marketplace. If he's saying, I don't watch sports, so I didn't know about Aaron Judge, and I don't know about his brand. I don't know about any of that. That means he didn't do a clearance search, because you don't have to watch sports to have done a research to see if these exact trademarks you're using is out there in the world, period. A simple Google search would have shown you that there are these brands that are associated with the very thing that you're trying to do. So you didn't do a clearance search. That's why the TTAB said, I don't care if you watch sports or don't watch sports. I don't care if you know Aaron Judge or don't know Aaron Judge. I don't care if you, what I care about is there's trademark law, and you either know it or you don't. And we know that we have to protect individuals from having their trademarks infringed upon. That's what we do know. So whether you did your due diligence and finding out what's out in the marketplace, that's on you. You assumed you had priority use. If based on what you're arguing that you're bringing here right now, and you know nothing, you assumed you had priority use and that you can go ahead and file this application under an assumption, not under the due diligence of doing a clearance search and a fact that you have this use. And not doing a clearance search means you underestimate existing use. You don't even care if there was something out there. You don't care if something did exist. I just know I have this. I want to federally protect it, and I'm going for it. I don't care about what possibly may be out there. That's the inference, right? Because if you don't know existed, you didn't have to watch sports. That means you didn't do any type of research. So a proper clearance search would have helped Michael and everybody else who will have to start over. And some of you, unfortunately, who are listening, who may have been operating with your brand name, imagery, sound, color, smell, whatever, for however long, you may have to start over if you never looked to see if you were clear to actually use it. If he would have searched, he would have seen, oh, there's this merchandise out here. There's this widespread use of this phrase. Here comes the judge. There's a all rise. There's a widespread use of this. There is this stuff out here. And if I go ahead and file, not only did I find that there is a use of these same trademarks, he would have found who's using it. Now, that is where celebrity comes in play. He would have found that a well-known individual that is associated with a well-known organization is using all of these trademarks. So I have a high likelihood of opposition. Registration is not a shield against reality. If you don't have a registered trademark, if you have not figured out the answer to the question that we started off with by now, if you don't have a registered trademark, it does not mean you have absolutely no rights. If you don't have a registered trademark, it does not mean you absolutely don't own something. What it does mean is it means that you possibly may not have rights absolute. It does mean you may not own something absolute because there's variables there without having this federal registration. But do know it doesn't mean you don't own or have rights. I want you to know that for you, but I also want you to know that for others. Just because someone else does not federally register their application doesn't give you the right to use a mark. If for some reason you do have an understanding that I have to do a clearance search and I've searched the USPTO and I didn't see it, it's not there. They didn't federally register it. And I hear these attorneys telling me that the first to file has the rights. I heard these attorneys and they're experts. They know what they're talking about. There's ESQ behind your name. You have to know. They said if I'm the first to file and I didn't see this in the USPTO, I'm going to go ahead and hurry up and file because no one else did. You need to know. You need to be checking outside of that USPTO. And a clearance search is complex. It is cumbersome. When you do a clearance search in a USPTO database alone, and anyone can tell you this, when you search whatever the slogan, phrase, imagery that you're looking for, you can get tons of hits back. Because when you do a search, you're not just searching for the exact phrase, slogan, imagery. You're searching for the exact and similar. Remember I said? And so you have to do variations of it. And this is why it's important to completely learn the process and or hire an attorney. I offer a in-depth empowerment trademark course that breaks down clearance search. And taking that course, it's a 4-part video. You're going to be on that one video. You should be on that one video for a minute because I don't give you slim pickings on this. I go in depth. I'm showing you how it's done. You will have to know how to search the exact word and variations of the word. You can have someone that has a trademark that says, be you for real. And the trademark is BEYOUFORREAL. REAL. Be you for real. And then somebody else said, okay, well, I put in be you for real. No one has it. But you don't put in B with just the B, the letter 4, the number 4, the letter U, and then real maybe REEL, because maybe somebody does reels or something. I don't, whatever. There's a variation of how to spell be you for real. So when you do a clearance search, it's complex. You have to do the exact and variations. There is a way to do that search on the USPTO database where you're not just keep typing in variations of names. There is a way that you're, plugging in variables that need to be plugged in that can substitute for numbers and letters that gives you multiple variations. So it's very complex. But in my course, I teach that. And what people then appreciate and also realize in the course is that, oh, I see why, one, hiring an attorney matters. 2, why it costs what it costs, because this is serious. We get thousands and thousands of hits, and then we have to go through those hits on the USPTO database to knock out what can possibly cause a likelihood of confusion, and then issue, which I should say competent attorneys should be issuing an opinion letter on what we found and what it should look like, and maybe have a conversation from there on the strategy moving forward of what you need to do. Maybe all is well, let's move forward. Or maybe there's a high likelihood of confusion and we have to re-strategize this. You may have to rebrand totally, or we may have to look at some other things. So hiring an attorney is important, but taking this course, even if someone after taking the course decide I'm still going to hire someone, they are so educated on what this process really is. It doesn't begin at the trademark application. It begins at the clearance search. And they're so educated on A through Z, and there's appreciation for it. But some will sit and they can study, they learn it, they go through it, and they use the course and watch the course and step by step going through it while they watch the course, however it works for them. But that empowerment course really gives people an understanding. And that's why I put it out there. I didn't want to put these trademark DIY trademark courses, like a lot of courses are out here, just DIY and help you understand the application possibly and do that. No, this is literally, I give you what I know. And now you're going to see and respect the process. And if you're going to go through the process from the information you know, you're truly going to respect and appreciate your federal trademark. But the clearance search is so complex. You have to look at the same and you have to look at similar. So yes, common law can win cases. And Michael couldn't believe it. He couldn't process it. Michael said, nope, I understand that TTAB said they're going to reject my application, but nope. I'm going to take it to court. And that's why I showed you that case. Let me bring that back up here so you remember here. That's why I showed you this. He went to the United States Court of Appeals for the Federal Circuit. Even after the TTAB, the Trademark Trial and Appeal Board is the board that's within the USPTO, gave their findings. He said, nope. I'm taking this. I'm appealing it. I'm going to the courts. And they looked at the same exact information. They looked at the same exact facts of what the TTAB did. They looked at the same exact thing. And they also said, nope. Judge have common law rights. He's going to win the case because of it. He's going to block your registration because of it. And his common law right protect his brand. It does. But moving forward, it will be wise, right, for Aaron to submit a federal registration for it because it does just strengthen what already exists. What helps judge that Aaron, that may be different than most people, is because of his notoriety, because of his celebrity, because of his backing, he can enter into licensing deals where individuals trust the licensing, trust the risks that are associated with licensing his deal without federal protection because of who he is, how he has become known to consumers, and again, who has his backing. Obviously, it's going to show this is just going to help him even more. He won a case without the federal registration, so that may help him with his licensing deals. But that's an exception to a rule, right? You have to have other factors that help people to move towards licensing your brand without federal protection. Generally, people need that licensing. They want to see that R behind your trademark. They want to see that it's federally registered, because if I'm going to license your brand, I'm going to pay money for this. We're going to enter into a partnership because of this. I want to make sure that I have recourse, and there's this extra cushion and protection with federal protection. It expands your rights. So registering your brand doesn't just offer protection from infringement. That protection is scalable because it communicates something different to other individuals, to investors and partners and collaborators. It communicates that I took the next step where I'm not relying on common law rights and having to prove these things. I have this national protection that expands all of these different rights. One of the protections you get, one of the expanded rights you get when you file for federal protection is, by default, you are presumed the owner of this trademark. And if someone has an issue with the trademark, they have to do all of the proving, not you. They have to do all the proving because you have federal protection. You already have presumption of ownership. And we know the one who has to do all the proving is the one who's going to more likely be spending all of the money up front and possibly on the back end. Because if you lose, you may get sued for legal fees for even bringing me through this crap. So federal protection helps there. So even in this case, though, Aaron, with his common law rights, he had to do all the proving. He had to do all the proving. He prevailed. He submitted all the things he needed to do, but he didn't have a presumption of rights. He didn't have presumption of ownership, even though he used it first. And all the reasons I listed earlier why he won, even though he showed all of that and won on that, he had to show it. There was not a presumption. At least Michael just had to sit back to see what he could show to defeat him. But Aaron's pockets are deep. But Aaron probably didn't have to spend the money. The Major League Baseball was right there with him. Players Association was right there with them. So he probably didn't have to spend money. So in his case, again, there's an exception to the rule. That's fine that he didn't have the expanded rights of presumption of ownership, assuming he's the owner. He didn't have to start there because I have the money to fight you. I'm going to oppose you and I'm going to have the money to fight you. And then I know I'm going to prevail and win in the end. But what helps other individuals who are not the Aaron judges out there in the world, it helps you to submit a federal application for protection because you get presumptions of rights. And your enforcement of those rights is survivable, especially if you federally protect your trademark. After 5 years, you get even more rights. It is harder for people to try to invalidate your trademark based on certain arguments. Pretty much you're foolproof by then. So here is the takeaway from this whole entire case that was more than about Major League Baseball. It was about ownership in the Major League, or being an owner. stepping up to that type of major league. The big takeaway is not having a registered trademark does not mean you have no rights. And that's important for you to understand that and dismantle that narrative for your own good and your own trademark. But it's also important for you to understand that because you shouldn't be out here walking around thinking because somebody else didn't register their trademark that you have a right to use it and you can be the first to file and now you own it. We don't want that misconception. The takeaway also was filing without checking for existing rights is one of the fastest ways to lose your money, your time, and your leverage. Clear and search, people, is important. You can be as creative as you want. Oh, I wrote this down. This is so creative. I have so many people came to me. Oh, can you file this trademark? I was so creative with this. And I look at the phrase and it may be creative in how they spelled the phrase, but what the phrase spells is not creative at all. Be you for real is not creative. I love you too is not creative. All these things that if I actually say what you're spelling is either generic or possibly already out there, it's not creative. So common law can protect you, but federal registration fortifies you. And unless you do have a celebrity status and a major organization backing you, it would be a great idea to level up on the ownership mindset of federally registering for multiple businesses, for multiple purposes. Protection and scalability. So you don't want to be building somebody else's foundation. And you definitely don't want to be interfering with one. So no fear mongering here. No change in the narrative here. To get you to do something that you have to have the mental wherewithal, fortitude, drive to do. No one should have to sell you on being the best version of yourself. You either got that, it's either in you or not. So understanding this truth will dismantle that fear-mongering narrative that you better federally register your trademark if you can, because if you don't own it. Nope. You don't own it outright because there's those possibilities, there's those variables that exist. But if those variables are not there, you absolutely do own it. You have senior rights and you can stop other applications just as much as people can stop yours. So in sharing this case, it proves that common law rights are not weak. They're just weaker because of all the things that you will have to do to prove. And again, possibly have to share. But it also proves how risky that a clearance search, not doing a clearance search is. That's what this case proves. So that's it. You're ready, right? And either way, if you want to learn more about the empowerment trademark course that I do offer, you can scan the QR code for that. When you scan the QR code, you can fill out information and just read about it. You don't have to commit to anything. You read about it. See if that's something you want. You get your whole client portal. This is not just you get a client portal that you can sit on, and you have access to the course, lifelong access to the course. You can study at your own pace. 4-part video, and amazing, I must say so myself. Ebook, trademark ebook, empowerment trademark ebook. It goes along with the videos. So you'll have visual, audio, all go together. The best way to learn, whatever your best way is, watching the video, taking notes in the book, and have many exercises in the book to practice your knowledge of where you're at. It gives you all the things. But if you also decide, I want a knowledgeable attorney to file my trademark for me, you can scan a QR code and you can get premium trademark services. You don't have to think about it. You can say, I don't want to think about it. I want to pass this off for you to do what you do in your lane while I preserve my energy to do what I do in my lane. And with that premium trademark services, it's exactly that. It covers from beginning to end, beginning of the clearance search process to the end of getting to the end of the decision of the USPTO examining attorney. And in between beginning and end, some of the things, it may happen after doing a clearance search. You're going to get that opinion letter. We will have a conversation. What is the likelihood of confusion? Have you been operating? If you've been operating a long time, have you been operating a long time without getting caught yet with infringement? Will you possibly have to coexist with someone else? Or are you completely clear? Depending on what that conversation is, it may be a strategy that needs to be taken for you to continue to exist, either possibly fully rebranding or making some tweaks. Who knows? And you know that I want an attorney to have those conversations with. You can do that. But I must say, even with the DIY course, there is an opportunity for you to say, I want to do the DIY course and I'm going to add on these other things. I'm going to add on that I want you to do this, or I'm going to add on I want you to do that, but I want the DIY course. So there's different ways to play chess. You can also say, I want the DIY course, study everything, attempt everything. And you say, I don't just want you to do this and that. I just decided I want you to do all of it. Then you can have the DIY course that you purchase credited towards the premium trademark services. So you still have the course, still have it, and that amount can be credited to your premium trademark services if it's done within a certain amount of time. So there's so many ways to go about looking around out here how to make happen what you need to make happen. It has to start here. Can't make excuses about it. But you have the QR code to the premium and to the DIY, and you have the information too of what's important to take into consideration. So thank you for tuning in into another segment of the Seek ELLAvation experience, where I know that I'm adding value to you through these powerful conversations. If you so happened upon this video, I highly encourage you to connect. Turn on your notifications. Tune in weekly. Because the more you know, the more you grow. The more you learn, the more you can earn. But not only should you connect, not only should you turn on the notification, make sure that you share, because the more you share, the more you show care. If you know there's another sports professional, creative, founder, first gen achiever that can benefit off of these segments, don't keep this knowledge to yourself. Share it. Spread the wisdom, especially with this segment. Tag a friend, repost. It's important. Very, very important for us to start moving differently in our world. We shape it. So until next time, keep striving, keep growing, and most importantly, keep seeking elevation. See you next time. Peace and progress.